Good afternoon, ladies and gentlemen. This is session 3 of podcasts about principles. And although this must be one of the longest titles in the history of podcasts in adult social care, it is worth unpacking what we're going to look at today. In a reasonably topical sense, it seems to me that councils are struggling to tell the difference between their powers and their discretions and their general duties under the Care Act, to tell those from the duties that are statutory, absolute, mandatory, enforceable duties, and then again from those other kinds of duties that are just as strong, but only when triggered by a professional judgment. As I do that and give you some examples, it will involve me considering en route what it means to act defensibly in terms of public law. And I use that word not by mistake for defensively with a V, but definitely defensibly with a B, because it is the essence of public law that the Judicial Review Court does not sit as a court of appeal from local authorities' social services decisions about care plans and budgets. You can't go to a judge and get the judge to tell everybody what the person needed or what the person should have been given. The judge only intervenes in a judicial review and quashes, not squashes, but quashes a local authority's decision if it is not defensible, if it is not a decision that any reasonable authority, properly instructed in the law and having the time to apply it on a day-to-day basis, would ever arrive at. And in that situation, if a judge intervenes on the basis that a council has got it that wrong, the judge simply says so, and the council has to go back to square one again. So, for instance, if the care plan was illegal, unlawful, a new plan has to be made. If the problem dates back to the assessment being dodgy in an unlawful sense, then the council has to go all the way back to square one. So the principles we're going to be looking at today are all about the difference between duties and powers, but also what it means to act defensively and therefore do a good job, which should mean that you can't be found responsible for acting unlawfully in a public law case. So why do I say that this is topical? Well, I think councils are floundering in a kind of functions fog at the moment. And of course, I have in mind in particular Birmingham, who has had to issue a Section 114 notice, which effectively confines it to doing things that it has mandatory duties to do. Birmingham has gone on record as saying how very difficult it is for them to know what their mandatory absolute duties are. And I think that they're struggling to tell the difference between enforceable duties owed to individuals, ones that are absolute, and ones that are owed to the whole community, and telling those ones from mere powers, which don't have to be discharged, especially if you haven't got very much money. And all I can say is that if I was a hard-up council, I know which ones I'd be focusing on. And I'm going to choose to look at the Care Act because adult social services law is the context for these free podcasts. I think councils are struggling to tell the difference between a duty and a discretion. A duty will always say the local authority must or the local authority shall, whereas a power will say a local authority may, or the guidance will say that a local authority can respond in a number of ways depending on what it thinks about this, that, and the other. If councils have got powers, some of them would seem to think that the best way of saving money is to say that they'll never exercise them, or that they will always do such and such. But the trouble with that is that it's also contrary to public law in the context of having a power to do something to fetter that discretion by deciding in a black and white way, never or always. Councils are allowed to have policies for the general guidance of the staff or for the public, but usually exceptions that may need to be made by management should foreseeably be spotted and maybe even described so that people know what hoops they've got to jump through to persuade the council to change its policy. There are some duties that at the moment, even though they are well known to be absolute and individually enforceable, that are being at the moment downgraded in actual day-to-day practice. So if you're a principal social worker listening to these podcasts, it's important that you remember that managerial edicts from on high, messing with the heads of the assessment and the care planning staff as to the kind of judgments required of them, even telling them how to think, what to decide, and how to word their recording, those amount to unlawful instructions from management. In the worst places, councils are doing all of those things, but waiting to see if anyone challenges their stances. And in particular, I can cite case law involving Merton, Redbridge and Suffolk, in which cases, decided cases where those councils have lost, the judge has struggled to find out who really made the decision, who made a decision properly and professionally and competently. So those are not good moments in the histories of those councils. In other parts of the country, some duties are being ignored because the people owed them are not just vulnerable people who would struggle to complain or to challenge. They may be people who are actually prevented by their impairment or their disorder from instructing solicitors without someone to act for them, called a litigation friend. In other words, incapacitated people. And we've got to the stage in this country where even the official solicitor is unable to allocate resources to help those people with a judicial review, for instance. So seriously underfunded is that arm of the justice system. And of course, I'm sure we all know that there are insufficient legal aid lawyers willing to take on that work as it is loss-making. And therefore, there is kind of lip service being paid to the rule of law rather than actual compliance. Social care departments often make whole swathes of their staff redundant. They leave empty posts vacant. Whereas ever since 1970, there has been a law that is still in force, and it says that social services functions deserve special protection. There is a duty on councils under this legislation, wherever there is an adult services director appointed, adult social services that is, that the council shall secure the provision of adequate staff for assisting him in the exercise of his functions. So if a local authority is using as an excuse, a perfectly true one, that it doesn't have enough staff to do the job, it is ultimately admitting to being in breach of Section 6.6 of this historic piece of legislation. And finally, when budget setting, I've noticed when you hear about it in the news that councils translate central government cuts into cuts for each of their departments in a pro rata or percentage-based way. Whereas the difficulty is that some departments have got more enforceable absolute duties than others. I've always used the example that, I don't know, Surrey in bloom cannot possibly be as important legally as meeting the needs of the people in Surrey who are eligible and who've got unmet need. So I've never really personally understood how this particular culture took over. So let's ask ourselves, are there some absolute social services rights born of statutory duties that even councils like Birmingham should be continuing to deliver on? I think people know that everyone, however well off in their own personal financial terms, everyone has got a right to an assessment to see if they count as eligible against national criteria that can't be messed with, if they can simply muster up the means to get facts over that add up to the mere appearance of needs for anything that could count as care or support. In the late 1990s, the council in Bristol tried to ration assessment on the footing that they didn't have enough staff. And they were told in the infamous Penfold case that assessment is not a service that can be rationed. It is a service that is triggered as a statutory duty by the mere fact of a person managing to get this far with their halfway decent account of their care and support difficulties. So it is clear that some duties are duties, even if there is a minimal amount of discretion about whether a person can add up the facts to trigger the duty in the real world. I think people also know that eligibility is based on the question whether you are unable to achieve 2 or more daily living activities from a list of 10, unable to achieve without assistance, that is, and without struggling too much with pain, anxiety, distress, or endangerment to yourself or others, together with the concept of whether you are experiencing significant impact from those difficulties. There is no need for your problems to be permanent or even long-term. Broken bones do heal, but one still has rights in the meantime if the situation warrants it. But I expect you can see that that's a slightly different kind of a duty, because before it goes through, as it were, a council officer has got to be satisfied that you are experiencing significant impact. And the chances are, as the going gets tougher with finances, probably people are becoming aware that they have to be a little bit closer to the edge of meltdown before people will be found eligible by social workers. I'm not sure that that's happening, but it used to happen, and I think that times are particularly difficult again now. Here's an interesting concept for a duty. If you are found eligible, then the council is obliged to provide you with adequate, appropriate and sufficient care services or funding to meet the needs. And please note, regardless of the state of the social services departmental budget. And why is that? And how can it possibly make sense? Well, it's the law, because there is a statutory duty to meet eligible unmet needs. And in law, it's the council's duty, not just the duty of one department within it. So, for instance, Surrey would have to cancel something like Surrey in Bloom if, in fact, they were too short of money in the social services department to meet the needs of people who had qualified under the eligibility criteria. When I say obliged to meet the need, regardless of the state of the social services departmental budget, but I say that you are obliged to meet need to a standard that is adequate, appropriate, and sufficient, there we are getting into the really juicy stuff. Because those are words that are inbuilt and woolly. And as far as the law is concerned, the law of judicial review, it is down to a council to decide how much of anything is enough to meet need. And wait for it, they can take the fact that they are more hard up this year than they were last year, and they can take the view that you're doing all right with what they provided you with last year, so that they could probably take a little bit away And on that footing, it would still be adequate and appropriate to meet the needs to the relevant level. Now, once upon a time, a council called Gloucestershire went to court about this kind of a principle, and the barrister said to the judge, do you mean that we could just basically provide less and less and less and less and less every time we did a review? And the judge choked and said, don't be ridiculous. The statutory purpose of the community care legislation cannot be ignored. You cannot take leave of your senses and leave people who would otherwise be in dire difficulties without anything. That's what public law is for, to lay down the line between how far you can mince towards meanness and then a line over which the courts will not allow you to go. And ever since then, this principle has been clear. The state of the budget is not relevant to whether the need is met, but may be relevant lawfully to how generously it is met, but subject always to contemplation of the statutory purpose and the existence of judicial review, which will draw a line. And when the barrister said to the judge, how will that line be drawn, please? The judges said, obviously, by reference to the standards of a civilized society. That is your bottom line. Councils, as I've said, can take austerity and their own budgetary difficulties into account. They can be less than generous, and they do not have an obligation to meet need in the exact way a person would like. On the other hand, though, they've gone over the line if they apply an arbitrary approach, such as only 4 visits a day, or no more than the cost of a care home would be if only we could find even a horrible one with an actual vacancy. Those guidelines for staff are not legal offers to make in the first place, and yet it happens nearly everywhere. So adult social services law is in a sorry state of affairs. Let me then make good this difference between duties and powers. It's a fundamental concept in public law, and a duty will always be worded in a directive way. The statute and the guidance will say the local authority must or shall. And a power will be termed in an optional and a more open textured way. The council, if it's told it may do something, it has a discretion to exercise here, not an obligation. And the fundamental difference is that a duty must be discharged, even if the council's team has no money, no providers, or no resources. The council is supposed to free up money from some other budget, that's the Surrey and Bloom example, or go back to delivering direct services to the public and just paying public sector salaries and pension payments, which is enough to make every council go bankrupt anyway. A power does not have to be followed through on if at least one considers whether one should exercise it. You can usually treat resources difficulties as a good reason not to do something. Not always, though, because sometimes even with a power, on the facts, the judge will tell you there is only one defensible response in a civilized society. A power to do something is not one that can just be put on ice. So that's why it is unlawful to fetter a discretion, even if you're given one in a statute. You must not allow policies to harden up into rules. And that's true for all policies of a council about how they choose to practice locally. Even powers have to be exercised compliantly with public law, and that means fairly. So you can't say, we'll exercise this power for all people with red hair, but not for all people who've got black hair. You're not allowed to be unfair in a public sector equality duty sense. You're not allowed to say, if people have got such and such in their factual situation, they can make representations to the panel, but nobody else can. That wouldn't be procedurally fair. And now we come to other differentiations that the courts have used. As the courts have been driving forwards public law principles for the last 3 or 4 centuries, it's the common law of how you regulate government, and it is down to the judges. They have to distinguish one case from another if they want to come to a different result. So often they look at duties, which would all look the same to people because they've all got the must word, but then judges imbue the wording with slight variations to explain why they think that they're different types of duties or duties with different consequences. So one really big difference judges make is whether a duty is absolute and enforceable and owed to individuals, or merely a general or a target duty owed to the whole community. With the latter kind of general duty, it's not likely to be interpreted to give rise to a specific duty to provide something to any one individual. And that's the kind of scenario where all a council has to do is to have a local offer and make that clear. There are some general duties too that would be hard to enforce because they are so very general. And that tends to mean that they're not treated seriously. Enforcing one of those in the Care Act, and I'll give you some examples soon, it would probably depend on proving that a council had literally given up completely on advice and information duties or commissioning duties. And no council has been allowed to do that as yet. Some of these general duties are more often called target duties. And the clue there is that there's no sensible means to measure how well something has got to be done under that duty. NHS functions, for instance, the Secretary of State's fundamental health service duty is to provide a comprehensive health service. Do you spot the woolly word there? Comprehensive does not mean whatever everybody wants. It means take a view about what is a reasonable expectation on the part of members of the public as to what the NHS is for. And that's why there are bits of the health service that are not free. And there are bits of the health service where you can whistle for your expectation and you will never get to the top of the queue. But fundamentally, it's why, even if you are at the top of a waiting list, and your life depends on it, if the ICU is closed that day because everybody's got COVID, you will not get your operation and you will not be entitled to compensation. There is no individually enforceable duty under that aspect of the NHS legislation. ICBs sometimes say, therefore, that continuing healthcare patients don't have a right to anything that is hard and fast. But that would be overlooking that the Secretary of State has directed ICBs that when somebody has a primary health need, they are owed the delivery of their personal health and social care needs. So that's like there's a general duty that can be hardened up to an individually enforceable duty if one has been found to have a primary health need. A general duty in the social care field is to commission for diversity, sustainability and quality. Those are wholly woolly words. And that can mean that market failure is just going to continue to be allowed to happen all around us. Another distinction is this: there could be a clear duty in legislation, but it may only relate to due process rather than to the substance of a right. And when you've got due process duties, judges have sometimes been persuaded that even though a council hasn't stuck to the duty, it shouldn't be taken to go and negate the essential validity of the decision or the legality of their acts. They should just get a rap over the knuckles and criticism. Whereas a substantive duty is more likely to be upheld as a fully enforceable duty, one where a breach will simply mean that the council is in much bigger trouble. An example of this may well be in the Mental Capacity Act. It's got a lot of due process duties to have regard to this, that, and the other, and to consult this person and that person and the other. So if those duties are breached by a local authority in the context of a Care Act function, the legal question that arises is, does that make the Care Act outcome unlawful? Obviously, the best interests decision maker will have lost their legal cloak of protection under Section 5 of the Mental Capacity Act, because that depends on abiding by Section 4 duties in the MCA. But the Care Act decision is probably not thereby rendered unlawful, and wouldn't be unless the similar point of the duty arose separately through pure public law principles such as fairness or through human rights law. So there's a nice grey area there that I can't be drawn any further on today. And finally, another area of debate in the case law can focus on whether a breach of a particular duty in public law, in the Care Act, for instance, should ever lead to liability in private law for compensation. In other words, for dosh, for damages, even though we're not talking about the law of negligence here. Would it be maybe better to see this financial compensation as restitution when an individual has spent money on doing something that the council omitted to do because it was simply failing to act properly under the Care Act? And so let's come now to the legal relevance of these sorts of distinctions. I have to say that I have mixed feelings about 3 conversations as a model for assessment, but I would be the first to say that, of course, assessment processes can be flexible and they must be proportionate. I accept that lots of councils have taken up a conversations-based approach, and the only thing I would say to them is, are they aware that the case law makes the actual validity of a Care Act assessment dependent on certain information having been explored? That's the Merton case. So if you come from a council where they don't really seem to be too well organised, members of the public probably need to query with their councils how exactly their Care Act paperwork achieves the following absolute duties in the law. Section 9(4) says this: a needs assessment must, duty, alarm bell, include an assessment of the impact of the adult's needs for care and support on the matters specified in Section 1(2). That's the well-being features that we looked at. Secondly, an assessment of the outcomes that the adult wishes to achieve in their day-to-day life. I haven't seen too many assessment conversations where that is written down. And thirdly, whether and if so to what extent providing care and support could contribute to the achievement of those outcomes, the ones that the adult is interested in achieving. And then I would flag up that the Merton case found as a matter of law, that if a council didn't follow this duty, that was no mere due process duty. That was a substantive duty that goes to the validity of the very assessment itself. So a Care Act process, whether it is called a conversation or something much more difficult, a Care Act process that fails to do this is not one that has been validly discharged. And all local authorities' monitoring officers need to be alive to that, because they have duties to look out, duties of their own, please note, to look out for contraventions of enactments. The assessment process involves these duties as well. Section 12.3 says the local authority must give a written record of a needs assessment to the adult, any carer, with the adult asking for that to happen, and any other person asked for by the adult to have a copy. After that, the process goes on, and it says in section 13, after an eligibility decision has been made, the local authority must, another duty alarm bell, must give the adult concerned a written record of the eligibility decision and, please note, the reasons for it. The statute says that. I'm not making that up. Section 17.6 says after any financial assessment, the council must give a written record of that financial assessment to the adult. And the local authority must give a copy of a care and support plan to the adult, any carer, again, if asked, and any other person, if asked. So all I'm saying is that however busy we are, we've got some absolute core duties that we cannot mess with, however attractive a streamlined process might be. When local authorities have policies, this is the law as to how they can be challenged. If a policy contains an assertion about the law, and that turns out to be wrong, but anybody following the policy will be breaching their legal duty, then that means the policy deserves to be challenged. And Suffolk is the council who most recently experienced that outcome when Suffolk's management told Suffolk staff that the meaning of support for Care Act purposes could not cover financial assistance for activities and breaks and holidays. Secondly, where the council that's pushing the policy does so pursuant to a duty to provide accurate advice about the law but fails to do so. In other words, when they get the law wrong or they just leave some bit of the law out. So, for example, any council which said in its advice and information pages that people with over £23,250 aren't entitled to present for a Care Act assessment, or said that people can't get Care Act services if they're under the mental health team, or that cleaning fees cannot ever count as disability-related expenditure, those bits of policy documentation would need to be challenged as unlawful. And then the third example is where a council, not under a duty to issue any document at all, chooses to do so and tries to provide a full account of the legal position but fails to achieve it, either because it gets the law wrong or it gives a misleading picture of the true legal position. So take a council, a hypothetical council, which has embraced a conversations model of assessment, but then ignores the Care Act, the stages that I've taken you through with a must in them, when deciding where to put these conversations in the general process of taking a person on a referral from the beginning, coming in at the front door, and then through to the end of the Care Act journey, at which point they're told that they're not getting something. That would be an example where a whole policy as to how assessment was to be done would need to be challenged. And then I want to raise something that councils can be forgiven for. because this is a really difficult topic and there's no books on it. Which duties trump other duties? Which duties come first? Which duties supersede others? Which is the most important law if there are two that seem to be inconsistent? Take, for instance, the Care Act and the data protection legislation. There may be a specific power to share information in the Care Act. It does not appear to require consent. In terms of the way that would work out, very probably the statutory authority in the power would be enough to share without consent. Generally speaking, the specific trumps the general, and the data protection legislation has got exceptions in it, one of which is statutory functions. What about this one then? To what extent does the Housing Act trump the Care Act? Well, for those of you who know, Section 23 says that whenever duties to people are owed under the Housing Act, duties to do the exact same thing under the Care Act are simply put on ice. The government and the legislature have decided that the housing duties trump the Care Act, and people shouldn't squeak around the side of housing legislation and come to the Care Act as a cunning way of jumping the homelessness queue. What about then the question about CHC? When does the status of continuing healthcare trump or exclude services under the Care Act? The answer is always. Section 22 says that you cannot receive social services under the Care Act once you have been found to have a primary health need. It is the government's choice that health must take the hit in that situation. What if the need is a health need but not a primary health need? That's a grey area where there is overlap and where it boils down to private integration agreements in all probability between health and social services. And when does the Mental Health Act trump the Mental Capacity Act? The answer is always. When does the Mental Health Act trump the Care Act? Well, an example is obviously with Section 117 aftercare. It pops up the minute a person comes out the door of the psychiatric facility, and on that footing, you don't qualify for Care Act services, you qualify for Section 117 aftercare services because they are specially free and not chargeable, even though they are not pure health services. What is the relationship between the homelessness provisions in the Housing Act and Section 117 of the Mental Health Act? I've made a mistake there and it says the Care Act. Can housing say, we don't do specialist needs housing, and your Section 117 Mental Health Act rights cover your accommodation? Or is it the other way around? And those who can get accommodated through homelessness don't need a roof to be provided for in their Section 117 plan? Who knows the answer to that? We think that there's a juicy test case lurking in that particular problem. A general principle that may help here is this. Whenever an act provides a specific framework for something with rights and obligations and protections, then generally it is not okay for a council or an ICB to use another woollier framework to achieve what they were supposed to achieve through the more specific protections. Another way of saying this is that the more specific a function is, or the more beneficial it is to members of the public in terms of it being free or enforceable, then that's the one that is supposed to come first. So I'm hoping that that's helpful. The remainder of the slides are, again, options for sussing out whether your local authority is doing something dodgy in terms of public law principle. So That's something to look through when you get the slides. There's two pages of that. And then there are some examples, just examples of different types of duties. General duties, probably only enforceable if a council publicly abandoned them altogether. Secondly, stronger duties, much more clearly owed to individuals, and they're all from the Care Act. I've deliberately stuck to the Care Act, so I'm not doing Birmingham's legal department's job for them. Here are some duties that must be discharged, but they depend on a professionally competent judgment first of all. And Section 9, Section 13 to do with eligibility, and care planning, when to stop negotiating and to say enough is enough, this is our offer. And when a direct payment must be given to somebody in Section 31. When advocacy must be provided under Section 67 too. And then we come on to powers that councils can have a policy about, as long as they don't let it firm up into an absolute rule. I've given you three to look at on that particular slide. Powers that turn on a decision from a professional, where the top tip is to look for words in the statute like if it considers or if it is satisfied. These are powers that very probably are not being discharged in this particular culture, this particular era. Then there are prohibitions and exclusions, things that you cannot do under the Care Act, because it says you shall not, you may not do it that way. Even if you've got a power to do it at all, you may not do it in a particular way. And the power to delegate local authority functions to anybody else is limited by these exclusions towards the bottom of the page. You can't delegate safeguarding, for instance. You can't delegate your charging functions to other organisations. I've ended up here with a bit of a mixture. Here's a power that can only be exercised with people's consent. A local authority may combine a care and support plan or a support plan with a plan relating to another person only if the adult for whom the care and support plan is being prepared agrees, and where the combination would include a plan prepared for another adult, that other adult agrees. We're talking here about combining care plans, and bear in mind that care plans have got to have budgets in them, and that budgets have to be calculated sufficiently for the individual. So when you combine a plan for two adults, it is likely because you think it will be a saving opportunity. But you can only do that when each of the adults agrees. There is no provision in this section for a substitute decision to be made about agreeing by even a welfare power of attorney or a deputy. And there's no mention made of any client's authorised person for direct payments having that authority to agree. And why am I going on about this? Well, it's because the whole of the supported living market depends on procurement and tendering exercises in which councils seek care providers who will or who are obliged to offer prices based on shared nighttime care for people with moderate to severe learning disabilities who will likely lack capacity to make those agreements to the shrinking of their own budget. One can only wonder at how that has never been challenged. And as we look to what I predict will be the end of adult social care law, enforceable legal rights within the next few years, I'm hoping that somebody will see a juicy test case which will make the supported living dependency in this country for people with impairments, a cleaner and a purer market. So that's the material for today. I'm opening up to anybody who wants to ask a question. I can see that there are no questions in the chat, but if anybody wants to unmute, they are extremely welcome to. Does anybody, I've got a bit more time today, anybody still in the session who'd like to ask a question about this very difficult set of principles? If you just unmute and put your video on, I think then that it becomes visible to me. Anybody game to do that?
Yes.
Yeah. Okay. Who's we'll do. I can't see the late. Is it Mary?
Oh, it's me. Okay. Oh,
yeah, Mary, you go first, Mary. Yep.
Yeah, this is my question. You know, direct payment under the law, if you have underspent, which you have set aside for a provision, can they take it back from you?
Can you be more precise about what you mean, Mary, please?
Okay, for example, there's this budget, they didn't provide certain services, and these parents cover some hours in order to put money aside in order to get those services for their son or daughter. And then social services said it's underspent and they have to claw it back.
Well, there are provisions in the direct payments framework for clawing back at least two types of money. Money that has not been spent because it was not needed, and money that has been misused. So again, I would have to drill into you and do cross-examination as to exactly what you mean. If you mean that the people couldn't spend the money because there was nobody who would do the job for the money, then that's a different question.
No, the issue is there's not enough budget given.
Yes.
So parents cover some hours. Like, for example, when the staff are on holiday, instead of employ somebody to cover for holiday, she will cover the holiday in order to pay this staff that the budget was not provided.
Yes, she needed to have challenged the adequacy of the budget at the time.
But they said it's enough for them to put the person in residential home.
Yeah, I'm afraid it's not an easy question, because there's only a 3-month period for challenging local authority decisions. So supposing you're worried, you've got your direct payment budget and there's not enough money in the budget to do something that was intended to be done. You need to go back to the council at that point and point out that the budget doesn't seem to be attractive enough to get anybody to do the job for you. And that's called challenging the sufficiency of the budget.
It has been challenged, and they said the money is the same as if they put the person in residential home. Therefore, they're not going to increase it.
Okay, so with a comparison with a residential care home, then you get into other aspects of unlawfulness that a local authority needs to be challenged for. But what you're proving to me is that I know this absolutely. People don't know how to challenge because they don't understand enough law. And if they don't understand enough law and they can't find the answer, then of course they end up just being fobbed off.
Yeah.
And that therefore becomes fatal. So thank you for that.
Thank you very much for answering. Yes, thank you.
Somebody else had a question, I think. Alex, yes.
Yes. Hi, Belinda. I actually had another one, but following on from the lady's question, I was wondering if I could ask you something regarding that direct payments there. If money, so are you saying challenging the sufficiency of the budget needs to be done if the local authority has taken out a significant portion of the direct payment due to it not have been used because of the rate that they were offering, and us being unable to attract the care needed by the service user dawn, they've taken the direct payment out. Would that have needed to be challenged? Is that what you're saying?
If you are saying that a local authority has already clawed back money
Yes.
for whatever reason, that decision is challengeable if there is no justification for having taken it back. So if you've said, why do you want to take this money back? And they say, well, you don't seem to have spent it, and it was for last budget year, not this budget year. And you then say, well, the reason I haven't spent it is because it was not enough to attract a PA to do a job, or it wasn't enough to cover the thing that it was supposed to cover because the cost of living and therefore the cost of that thing went up, then they are entitled to turn around and say to you, you should have told us at the time.
Okay,
Okay.
but okay, I understand that. And can I ask just a second question quickly, please?
Yep.
It was about.
You've muted yourself, Alex, by accident.
Sorry.
Yep.
Yeah. Earlier on, you mentioned, alluded to management, basically,
Telling people how
taking
to think.
control.
Yeah.
Yeah. Well, my partner Dawn, she had her first appointment with a social worker, and that social worker was very nice, but she goes, all decisions are going to be made by management. Basically, my hands are really tied. So I think you're aware we're at the stage where we very kindly, because of your help, we got the assessor, the brain injury assessor.
It's not appropriate to discuss that here, but what I wanted to say is very simply, a social worker who comes and says to you, my hands are tied, is not saying that they've been told how to think. A social worker who comes to you and says, my recommendation is going to be X, Y, and Z because that's my professional judgment, but I'm not the actual decision maker. The panel is, they are not misrepresenting the law. Okay. I was talking about an example where Suffolk, for instance, told their staff to constrain their whole approach to the breadth of assessment because Suffolk's management had decided that the word support could not cover financial assistance for activities. Okay. If you take, for instance, an occupational therapist who is told how to write their report, regardless of their thinking, that would be wrong. But the fact is that local authorities are entitled to have a panel make a decision based on the recommendation of the professional social worker or the care manager. The thing is that people always forget is that if the panel disagrees with the social worker, the panel has got to give defensible, rational, evidence-based, more persuasive reasons than the social worker. Otherwise, they have just overridden them.
Okay, yeah, here is a case where the social worker is saying she has to go to management to make any decisions. So it's different.
But that's slightly different. Okay.
Yeah, completely. Thank you.
Yeah.
Thank you.
Bernadette, you had a question. If you're still there.
Yeah,
hello.
hi. Yeah, I just wondered, this has been about adult social care, but I wondered about how care and support planning, what are the rights the same when you're under continuing healthcare?
Yeah, it's a really good question, and I dealt with it last week to a large extent. And the whole point was last week we were looking at the guidance, and the guidance, of course, puts the flesh on the bones of the Care Act. I was saying that the principles of the guidance, albeit about the Care Act, are themselves based on public law and human rights. And therefore, they make up as good a body of principles as any ICB could ever want to work to. However, there are some specific bits of the Care Act that simply don't apply to ICBs. And a good example is choice of accommodation rights. There is a commitment to choice in the NHS Constitution, And there are paragraphs in the NHS National Framework for continuing healthcare clients about how care planning should start off with the preferences of the individual, but no absolute right to choice, subject to paying a top-up. Whereas in the local authority sphere, there are specific provisions in the Care Act providing for choice of accommodation. Okay? So the particular example that I was amused at last week, Bernadette, was somebody had come to us and said, my ICB is saying that they don't have to share the budget with us. They don't have to share their assumptions. They don't have to point to evidence about the rate that they're paying because it doesn't say so in the national framework. And I would just say, bring it on, go to judicial review, and you'll do everybody a favour and establish that the principles largely from the Care Act should be taken to be the principles that should govern ICB care planning.
Thanks very much, because that's more or less what I have been saying, but I'm having a difficulty in that it seems to be there's a two-tier system, that it seems to be there's more rights in social care with your care and support plan to its implementation, where it comes a bit sort of fuzzy in continuing healthcare.
I agree.
Yeah.
But one reason in particular, Bernadette, is that everybody understands that, I think they do, a challenge to an ICB's decision about whether you are eligible for CHC goes to an independent review panel and then internally up the system until you get to the Health Service Ombudsman. Whereas a challenge about basic adequacy of care planning is a straightforward judicial review.
Okay, that's great. Thank you.
All right. I see there's one question in the chat, and I'm just going to read that. Hannah asked as follows. With regard to disability-related expenditure, we've received a request to include the expenditure for a dog who provides emotional and psychological benefits to the owner. The owner has eligible needs, but the dog does not meet any of these eligible needs. The dog does not meet any of these eligible needs and therefore has not been included in the care and support plan. Is this correct? Well, there is a fundamental distinction between the approach a council takes to what needs to go into the care plan and what counts as disability-related expenditure. There is no doubt that people can get assistance dogs, sight and hearing dogs, all sorts of road safety dogs. They can get those from specialist charities, and the local authority doesn't have to pay for them. The individual would then need to feed the assistance dog, and that would be a good example of DRE that should be allowed, but which would not be in the care plan. In this particular example, it doesn't surprise me to be told that the dog is not in the care plan because it doesn't meet any of the eligible needs. But the question is it okay to just say, because it isn't in the care plan, it can't be DRE? It would definitely not be correct to say that. And there is recent Ombudsman's decision-making about the distinction between those two approaches as to what is needed. I'm not saying that it would have to be allowed as DRE. I am saying that if it is a person's decision to spend their private money on something that meets their emotional and psychological needs, if those needs are related to their disability, then it could be DRE. And whether it's challengeable or not to say no, it isn't, depends on how good a job the financial assistance team have done. So that I hope that that is clear. Right then, thanks very much. Oh, Mina, one question from you before we finish.
Yes, it's to do with supported living and budgets. Could you refer me to the section in the Care Act which says that an individual's budget must be based on their eligible needs and not that can't be shared? So I can't, you
Yes,
referred,
it's section 2511. It
okay,
doesn't say, I've just put it back up on the screen. It doesn't say that a person's budget has to be individually calculated, because the whole of the rest of the Care Act says that.
okay,
It provides for an exception to an individualized budget in section 2511, but only where everybody affected by that agrees. And my point, of course, is that very often in supported living, the people whose budgets are being combined because savings can be obtained by 4 people having 1 person to look after them at night, that has not been agreed.
thank you.
Excellent. Right.
Thank you.
Oh,
Good
thank
luck
you
with
very much. Thank
good luck with that one. Thank you very much. Cheers. See
you.
you again next week. Thank you.
Yeah.
Bye. Bye.